A groom went to court to claim money that had been promised to him. The money was meant for him, the agreement was made for his benefit, but yet the court said, no, you cannot sue. Why? Because he was not a party to the contract. Welcome to the Contract Law Doctrine series. So today's doctrine is the Doctrine of Privity of Contract. This doctrine was famously established in very important case law in 1861. In this case, the father of bride and the father of groom entered into an agreement and promised to pay money to the groom. When one of them failed to pay, the groom tried to enforce the agreement, but the court refused. The reason was simple. The agreement was between the two fathers, not between son and father. The groom was supposed to be benefit from it, but he was not a party to the contract. And that's exactly what the doctrine of privity of contract says. Only the parties to a contract can sue or be sued upon it. In simple language, if you are not a party to contract, you cannot generally enforce it, even if the contract was made for your benefit. Of course, there are few exceptions. For example, in Khwaja Muhammad Khan versus Hussaini Begum, the court allowed a beneficiary under a marriage settlement to enforce her right. Trust beneficiary can also enforce their rights despite not being party to the contract. So, the key takeaway is this: a party may benefit from a contract, but that does not automatically give them the right to enforce it. And that is the doctrine of privity of contract. Follow for part 2 of the Contract Law Doctrine series. Thank you for watching.